Director Cordray, how are you? I've heard criticism that the CFPB is conducting regulation of financial products and services through enforcement actions and through guidance bulletins rather than through notice and comment rulemakings, which of course would include input from the public and input from Congress. Since its doors opened, I think the CFPB has finalized 54 rules, 18 of which were part of congressionally mandated regulations, and at the same time issued 34 bulletins and 23 enforcement actions. So if you take out the congressionally mandated rules, that means the CFPB issued the same number about of rules as it did bulletins. 36 rules, 34 bulletins. The 23 enforcement actions often include specific business reforms. So the CFPB promotes the bulletins as statements of law and policy and the enforcement actions as deterrents, yet in both cases the agency appears to be making policy without obtaining public input, if you follow my logic on that. So if the CFPB intends to impose specific new requirements, would it not be better for the agency to use the rulemaking process, which has the benefit here of notice and comment periods, rather than enforcement actions and bulletins?
So we can do that, and of course are required by law to do that in appropriate instances, particularly where we're making substantive changes in the law pursuant to congressional delegation. On enforcement actions in particular, I don't think there's a law enforcement agency in America that requires a notice and comment process before engaging in enforcement action, because you're by definition responding to potential violations of the law, and having that drag along while you're allowing lawbreakers to operate is not appropriate. I don't think that would be. I think the issue that you raise is around some of our guidance and bulletins and whether those should be done with notice and comment. So they're not required to do so. There have been lots of instances where we have put things out for notice and comment. We've done a lot of requests for information to get a lot of input from people, and we're very accessible to people. We have so far tried to hew very closely to what we understand the law to be in this area, which is notice and comment for substantive administrative rules, and not for guidances where we're simply clarifying and laying out the law as it's already, we believe, understood. I believe the U.S. Supreme Court has just granted a case around interpretive rules where they're going to, sometimes this is a difficult line to draw, and they're going to try to clarify that next term.
But let me just walk you through sort of
Sure.
example here, because
Yeah.
Regulation conducted through enforcement often results in confusion. So I'll give you an example, and I think confusion can be harmful to consumers. So by way of example, the CFPB has issued 4 enforcement orders against banks in connection with the marketing of debt protection products. Each of the enforcement actions imposed quite different remedial measures. So banks, of course, under this circumstance, are not certain of what is required of them to safely sell these products. Many have stopped offering the products to consumers. And then a subsequent bulletin related to add-on products did not resolve this uncertainty. So hence the thought here. If you could clarify the agency's position on debt protection products so the financial services industry could understand what is expected in connection with these products, and does the CFPB have concerns about debt protection products themselves or just how these products are marketed. But the fact that every case is handled differently with different remedial measures leaves that big question mark.
So it's a fair concern. The remedial measures depend critically on the facts and circumstances of that matter. If the institution was marketing these things, telling people that they were signed up when they weren't, that's going to get a certain response. If they're telling them that the product did this and it didn't, that's
I hear you. There could be 4 examples, but I've been told that other federal agencies often enlist the use of advisory opinions to help businesses seeking clarification on specific practices. Would the CFPB consider issuing similar advisory opinions? Because then you might have them know on the front end exactly what was expected, what wasn't, and you wouldn't have arguably 4 different results.
That is something we're working to do in appropriate cases, and the SEC has done some things, and we've looked at other agencies, and I do think we can probably do more in this area, yes.
Yeah, I think that would move you more towards the input from the public and input from Congress and input especially with respect to those that are going to be impacted, understanding exactly where you're going with your rulemaking. Thank you.
Time of the gentleman has expired. The chair now recognizes the gentleman.